11 ENGRACE Niñal for herself versus NORMA BAYADOG. GR number 133778. March 14, 2000. Facts. Pepito Niñal was married to Teodulfa Bellones on September 26, 1974. Out of their marriage were born herein petitioners. Teodulfa was shot by Pepito, resulting in her death. 1 year and 8 months thereafter, or on December 11, 1986, Pepito and respondent Norma Badayog got married without any marriage license. In lieu thereof, Pepito and Norma executed an affidavit dated December 11, 1986 stating that they had lived together as husband and wife for at least 5 years and were thus exempt from securing a marriage license. Pepito died in a car accident. After their father's death, petitioners filed a petition for declaration of nullity of the marriage of Pepito to Norma, alleging that the said marriage was void for lack of a marriage license. The regional trial court dismissed the petition. Issue: May the heirs of a deceased person file a petition for the declaration of nullity of his marriage after his death? Ruling: The two marriages involved herein having been solemnized prior to the effectivity of the Family Code. The applicable law to determine their validity is the Civil Code, which was the law in effect at the time of their celebration. A valid marriage license is a requisite of marriage under Article 53 of the Civil Code, the absence of which renders the marriage void ab initio. The requirement and issuance of marriage license is the state's demonstration of its involvement and participation in every marriage, in the maintenance of which the general public is interested. However, there are several instances recognized by the Civil Code wherein a marriage license is dispensed with, one of which is that provided in Article 76. Referring to the marriage of a man and a woman who have lived together and exclusively with each other as husband and wife for a continuous and unbroken period of at least 5 years before the marriage. Consequently, void marriages can be questioned even after the death of either party, but voidable marriages can be assailed only during the lifetime of the parties and not after death of either. In which case the parties and their offspring will be left as if the marriage had been perfectly valid. Contrary to the trial court's ruling, the death of petitioner's father extinguished the alleged marital bond between him and respondent. The conclusion is erroneous and proceeds from a wrong premise that there was a marriage bond that was dissolved between the two. It should be noted that their marriage was void, hence it is deemed as if it never existed at all, and the death of either extinguished nothing. However, other than for purposes of remarriage, no judicial action is necessary to declare a marriage an absolute nullity. For other purposes, such as but not limited to determination of heirship, legitimacy or illegitimacy of a child, settlement of estate, dissolution of property regime, or a criminal case for that matter, the court may pass upon the validity of marriage even in a suit not directly instituted to question the same, so long as it is essential to the determination of the case. Wherefore, the petition is granted.